You know, and throughout the day, you've heard reference to the SEC, and I got to say, with this next session, we're fortunate, very fortunate. We not only have Brian Jenkins, who's a former CNN news reporter, going to moderate the session, but Ryan Van Grek flew in from the SEC just to do this session. So with that, I'd like to have you come on up and take the chair up here.
So this is the discussion on the SEC perspective on blockchain. Our guest, Ryan Van Grek, just flew in from Washington this morning, so let's give him a big Windy City welcome. Now that we've overcome any post-lunch drowsiness, I would like you to grab those cards. If you have them, I would like you to turn to the person on your left and hand them a card. I hope you did a little networking on your own during lunch and will stay for the networking session at the end of the day. But I am a firm believer in networking, and if you haven't already, turn to the person on your right and hand them a card. And so many of you have laptops. I won't make you stand up, but hand a card to the person behind you. And if you're in the back row, don't break your hand on the wall. Okay. Let's make a vow that before the next blockchain summit, we will each do business with one person at least in this room. Please do take advantage of the networking session at the end of the afternoon to pass your cards out, meet more people. That's how we're going to make Chicago the leader in blockchain in the Western Hemisphere. I would like to say a few words about Ryan. He is a special counsel and advisor to the co-directors of the Enforcement Division at the Securities and Exchange Commission. He also leads the SEC's Fintank Working Group, so he's right at home with this bunch. Before joining the Enforcement Division, Mr. Van Grek was senior advisor to the chair of the SEC, Mary Jo White, a Midwestern native from Kansas City who I got to know during the 90s when she was the U.S. attorney in Manhattan, and I was covering all of the terrorism trials for CNN in New York. From 2014 to 2017, Ryan was counsel for a broad range of regulatory matters for Ms. White. Before his time at the SEC, Ryan served in the White House as Deputy Associate Counsel, where he oversaw the selection, examination, and confirmation of the President's cabinet and handled congressional oversight issues. That's almost as big a portfolio as Jared has these days. Ryan grew up in Rockville, Maryland. He became a Blue Devil at Duke, and he earned his JD at Harvard Law. So we're really thrilled that you're here today.
Great to be here.
We've covered a lot of topics today. Let's start with an overview of how the SEC is looking at FinTech. What are the main areas of your focus?
Great. Well, thanks. Can everybody hear me all right in the back row? Everybody good? Great. Well, thanks, Brian, for the introduction, and thanks to all of you for hosting me here today. Very happy to fly out here to speak to you all. I think it's great what you all are doing in Chicago and seeking to do in Chicago, so I am certainly personally pleased to be here. I have to start with the requisite reminder that the views I express today are my own and do not necessarily represent the views of the Commission or the staff. Innovations in FinTech, which is what I'll kind of start with, have the potential to transform really kind of every aspect of the securities industry, from streamlined market operations to more affordable and efficient ways to raise capital and advise clients. Those changes compel us to think carefully about how best to protect investors so that they and we can feel comfortable and have confidence in these new products. And with that rapid change and innovation comes a heightened responsibility on innovators and regulators alike. It is incumbent on entrepreneurs to be mindful of the fact that they operate within a broader regulatory environment. You know, a technologist waiting to the finance industry must recognize they are not only innovators, but also market participants with important duties and obligations to investors. But on the other hand, regulators must evaluate how existing rules and regulations address both the challenges and the opportunities presented by these new technologies and do so in a way that doesn't stifle innovation. So I want to just briefly touch on 3 areas that we're focused on at the SEC. There are more, but I'll be brief and just mention 3, which is blockchain technology, online marketplace lending, and automated investment advice. Naturally, given today's topic, I'll start with blockchain technology, which has the potential to greatly impact how the securities industry operates, promising new ways to place, clear, and settle trades, and novel ways to issue securities and raise capital. We are closely tracking and monitoring the technology and already are addressing it in certain contexts. The Commission, for example, has solicited comment on the utility of distributed ledger technology in recent rule proposals related to transfer agents and the shortening of the standard settlement cycle. And we're also mindful how it could impact capital formation. The Division of Corporation Finance continues to evaluate potential offerings of DLT-related financial instruments, including the rise of initial coin offerings and other similar vehicles for raising capital using distributed ledger technology. I know I heard in the last panel there was mention of our 21A report, which we issued in July, which addresses the applicability of the federal securities laws to certain offerings that use blockchain technology. In terms of online, or I should say automated investment advice, it's another kind of technology we're closely monitoring. These so-called robo-advisors offer discretionary investment advice using algorithms and have minimal, if any, direct interaction between the advisory personnel and the underlying clients. In February, our staff issued guidance related to robo-advisors that highlighted that there could be certain Advisors Act considerations and obligations with this new model. And earlier this year, we launched an examination initiative about robo-advisors in which we're examining their compliance programs, their marketing, cybersecurity, and data privacy areas. And then a third area we're closely monitoring is online marketplace lending. From the SEC's perspective, we're most interested in determining whether the activities on these platforms are made in compliance and following the federal securities laws. And so, for example, the securitization of those loans, whether those should be registered. As with other fintech developments, investor protection is a key consideration there. Now, as part of our growing focus on these and other issues, we have enhanced our coordination within the Commission to make sure that we are kind of addressing these issues comprehensively and deliberatively. And so last year we formed the Fintank working group, an internal working group, consisting of senior staff from across the agency. And together we evaluate these emerging technologies. We interact with industry to understand the developments, and we're trying to determine what the SEC could best do to clarify where that's appropriate and engage and have outreach with the industry. We also, last November, had our first ever FinTech Forum, which brought together market participants, entrepreneurs, and thought leaders to discuss some of the most significant and pressing issues impacting the industry. And with our new chairman, who came this spring, Chairman Clayton, we've continued to make great progress. The most recent development is we launched an email address, which is fintech@sec.gov. And it is an email inbox monitored by myself and a few other fintech-related experts in the building, and it is a vehicle for anyone in the industry or anyone who has a question related to fintech to reach out to us and have direct communication. We are responsive, and we make sure that we're putting you in touch with the right people. So you'll hear me plug it a few times today, but I encourage all of you, if you have fintech-related questions, certainly where appropriate, get securities counsel, but also to the extent you feel it may be necessary, please do use that inbox.
Terrific. This morning we heard from Jennifer O'Rourke this morning about blockchain initiatives at the state of Illinois. What are you hearing from regulators in the states and in other countries, and is there coordination among regulators?
Absolutely. So one of the benefits of our working group is the ability not just to coordinate within the agency, but also with our fellow regulators, both domestically and abroad. And that is undoubtedly going on. So domestically, we have regular communications and meetings with our counterparts at the CFTC, the Federal Reserve, Treasury, CFPB, all of which have kind of stepped up their game in the fintech space. And internationally, we've had, in just the last few months, conversations with our counterparts in Ontario and Canada, in the UK. So rarely, I think, a few weeks goes by where there's not some sort of communication or outreach. We're also involved in some international efforts involving fintech at kind of broader stages. So there's IOSCO, the International Organization for Securities Commissions, as well as the FSB, the Financial Stability Board. Those are two international organizations of regulators that are starting to get involved more in both the DLT and fintech space more broadly, and we participate in those conversations and contribute to reports, a few of which have already been issued earlier this year. But in terms of what's happening at the micro level, you really are seeing many, if not most, regulators, get at home and abroad, getting more involved in this space. The CFTC launched their Lab CFTC initiative, which is aimed at enhancing their outreach. I mentioned we have our working group, we have a fintech forum, and we have this new email address. FINRA announced an initiative to help enhance their outreach with the industry. And abroad, you also see the UK's FCA, you see in Australia, in Ontario, and many other places, they all seem to have launched some sort of group or initiative or effort aimed at, they all have slightly different aims, but there's a common theme among all of their efforts. Oftentimes it is to enhance the outreach and coordination with the industry so that the regulators can learn more and entrepreneurs and market participants can feel comfortable stepping forward. And then a lot of them have also used these efforts as a way to further provide guidance or at least shed a little bit of light on how they are kind of evaluating these issues. The one thing I will say is these efforts do seem to be accelerating, and I think that's probably obvious to many of you, and there was discussion about what's going on in the ICO market in the last panel, but you are seeing regulators speaking to these issues with much more regularity and frequency, and I don't see any reason why that's likely to slow down over the coming years.
Okay, let's drill down a bit when it comes to blockchain technology, specifically with respect to distributed ledger technology. What steps has the SEC been taking to better understand developments in that area? And what do you see as some of the potential benefits and risks that firms should consider as they develop DLT applications?
So the SEC has taken several steps in the DLT space. I've already mentioned a few in terms of soliciting comments for some of our rule proposals. We've greatly enhanced our interactions with firms through events like our FinTech Forum and our email address. We are having much more regular kind of conversations and communications with the industry, which has been invaluable to us and I certainly hope valuable to those who have come in. And just independent of all of that, we continue to evaluate DLT-related products and financial instruments. I mentioned we have a FinTech working group, but within there we also have a more focused distributed ledger technology working group, which is exclusively dedicated to blockchain-related developments, which allows us to drill down even further, and we have a lot of expertise that we've developed within that group. In terms of the benefits and risks, I would just first highlight, perhaps above all, that concepts like blockchain technology and the idea of a distributed, decentralized organization that runs itself through smart code, that was unimaginable until fairly recently, and now it exists. And so I think it's clear to me that the potential benefits and opportunities from DLT are considerable, and we're seeing a lot of those possible applications in the securities space, including with respect to settlement and trading and clearance, and as I mentioned earlier, with respect to capital formation. But I would underscore that a lot of these technologies are being integrated in platforms and systems and processes that often fall or seem to fall squarely within the Commission's kind of regulatory orbit in some fashion. And though I think a lot remains to be seen in terms of where the technology will ultimately lead, I think it's clear that the pace of progress is accelerating, and that a key consideration in light of this innovation is, in my opinion, both simple but significant, which is simply that a lot of the DLT activity is potentially taking place within existing regulatory regimes, whether it's the SEC or elsewhere. And so I think it's very important and you heard from the lawyers, the last panel, to be mindful of the fact that you may be engaged in activity that falls within an existing structure, and you should be engaging with your lawyers or with your regulators, as early as possible. Certainly, as the primary regulator of the securities industry, the Commission has an interest in encouraging innovation that benefits investors, the markets, and capital formation. But at the same time, we have to remain vigilant in our mission to protect investors and in our markets against harm. But in thinking through and balancing those considerations, it is important to keep in mind that the SEC's focus generally is not so much about regulating technology as it is really about regulating conduct.
So what kinds of misconduct and abuses are you seeing in the DLT space, and what should DLT firms keep in mind in terms of regulations and living up to those regulations?
So the SEC has brought several cases in the virtual currency or DLT space in some fashion over the last few years. Those cases generally have fallen into three buckets, more or less. One is kind of Ponzi schemes or investment frauds. Another is unregistered offerings. And then a third is unregistered trading venues. And so, for example, in 2013, the SEC versus Shavers matter involved defrauding investors in a Bitcoin-denominated Ponzi scheme. In 2014, we charged a Bitcoin entrepreneur with the offer and sale of unregistered securities in a Bitcoin betting game. And just this past summer, we filed an action and obtained an emergency asset freeze against the founder of a purported Bitcoin platform, alleging that he had defrauded investors. Now, there are kind of two significant takeaways, at least that I have from those sets of actions. One, those cases involved significant relief, including tens of millions of dollars in disgorgement and penalties ordered, and bars from working in the securities industry. But I think what's particularly notable is that these cases, in many respects, are no different from the traditional cases that we bring at the SEC. Parties defrauding investors, parties failing to register in one form or another. Those are core SEC enforcement issues, just being kind of experienced through a different technology or through kind of purported investments in that technology. And so, to some extent, I think history and past precedent, although never maybe squarely applicable when we're talking about new technologies, but can be very informative into how we at the SEC are thinking of many of these issues.
Okay, let's talk initial coin offerings. We heard this morning comments that China, as most of us know, has banned or at least suspended ICOs. The SEC issued a report in July. What effect has that report had? What activity have you seen since then, and what do you anticipate going forward?
So, initially, I think a lot of DLT-related activity in the securities space seemed to be anchored around the clearance and settlement and trading process, but of late, a lot of attention has been dedicated to capital formation issues and certainly these initial coin offerings, which I think by last count have raised over maybe $2 billion in 2017 alone. I don't need to, I guess, tell many people in this audience, we issued our report in July, our 21A report, that addressed the applicability of the federal securities laws to this new paradigm. We wanted to make clear with that report that simply using virtual currency or distributed ledger technology does not remove a transaction from the purview of the federal securities laws, and that each offering needs to be evaluated on a case-by-case basis based on the facts and circumstances. But building on that 21A report, in the last few weeks and months, we've filed several other enforcement cases with some nexus to the ICO industry. Just a few weeks ago, for example, we filed charges against an individual and two companies alleging they had defrauded investors related to purported ICO and token sales. And in August, we issued an investor alert about the public companies making ICO-related claims, and that in those instances, we issued several trading suspensions of the common stock of certain issuers. And I think if you read closely those trading suspensions, our recent enforcement action, you certainly see us getting more involved in the space. But I think what's the other interesting component there, we talked about China, is that other regulators over the last few months have also gotten involved and issued guidance or certain statements. And you have kind of a spectrum of reactions. You have China and South Korea recently coming fairly strongly on the side of going against initial coin offerings. And then you have other regulators in the UK, Hong Kong, Australia, and many others who I would say taken a more nuanced approach in which they've provided some sort of guidance while also often flagging some of the potential risks involved. And I think over time you will see more regulators weighing in. It's only been a few months, I guess, so it's still early days. But they're probably going to fall along the whole spectrum. You have more extreme and more and maybe more subdued reactions. But I do think you'll certainly see more of those. I would suspect in the months and weeks to come.
Terrific. Question from the gentleman in the second row.
Yeah, you talked about regulatory actions. CFTC has come out and said, they think that in their purview, there's two because and Letrax was approved as SF. SIBO down the block is looking to get approval. What is the SEC's official position at Bitcoin? Do you think it's a security, or does it matter? Does it have to do something with it? And are you working with the CFTC? Is there a conflict as to who's ballpark that holds it?
So it's a great question, and one that we've continued to have to confront in a variety of areas, and one where we have not kind of taken an official position. So I don't have a definitive answer for you. But what I can say, and you're right, the CFTC has taken some steps. We do communicate and coordinate with the CFTC on fintech issues. I know well they're the head of their innovation office. So there certainly is regular communication between regulators, and the CFTC is no different. But you are right that they have come down more definitively in certain areas. At this point, there are a few very live issues at the SEC, so I can't comment on that specifically.
Action, under what authority are you taking an enforcement action on
Which action are you referring to?
what you had just mentioned, a couple of enforcement actions?
Right. So, but it all depends on what you're referencing. So, if you're talking about initial coin offerings, so the trading suspensions, we're dealing with issuers that were certainly within our space, and the 21A report itself wasn't an enforcement action. It was a report, but in that report it noted that tokens or coins could be securities, and so in that vein, if what you have is a security, that would very naturally fall within our purview. But what constitutes security is going to be a fact and circumstances test, which is why, and I'm sure it's frustrating to some, but why it's difficult in any particular instance, or to speak generally or globally about whether something does or doesn't fall squarely within the SEC's jurisdiction.
Question, sir?
I wanted to address, you mentioned capital formation. So just as we've introduced the Jobs Act, the Reg 8 Plus offerings, how do you see ICOs falling within that purview or in helping companies raise capital more easily? And then attached to that is, what do you believe as folks are going out with the ICOs? Are there any, you believe, sort of safe harbor provisions that they may be doing in terms of going out now and being protected as regs change in the future?
So I guess two components to that question, and I think it certainly appears that people are using ICOs as another potentially easier or cheaper way to raise capital in terms of how it functions within the broader regulatory regime and as it relates to other areas. This is it is still a fairly new phenomenon. I think the SEC was one of, if not the first regulator to provide any sort of guidance in the space, and we are closely monitoring it. But I think there's also the need to proceed kind of deliberatively and cautiously in terms of understanding the market and the regime. And so part of what we've done to effectively and in part answer some of those questions is through this email address, fintank@sec.gov. We're communicating much more frequently with those in the industry, those who are seeking to raise funds, those who are involved in some of the kind of the secondary trading, or others that are impacted by the ICO market, to learn from them, to hear from them, to see what they're doing, and to gain insight from their observations, so that when we do weigh in at each of these increments, it's from a kind of a much more kind of informed perspective. And I think that's in terms of the second part of your question. You have to remind me.
The
Right. So, I mean, that's always kind of a topic of consideration, but you're talking about when regs change. There hasn't been any regulatory change in that regard, and so I think that's something that we'll have to come to depending on what those changes are, but certainly a very good question, and one that you'd want to be focused on.
Any other questions upstairs? Yeah, in the back row.
Jobs Act, the SEC allowed non-accredited investors to invest in startups up to a certain amount. I think it was $50 million. Obviously, with ICOs, you get craziness like Bencor and Pezzo, $250 million raises. Is this something that kind of the SEC is looking at maybe capping in some way, or creating some sort of regulation that will provide the same sort of levels that you have in the Jobs Act?
Well, I think I think right now what we're most focused on, or at least kind of there's. I wouldn't say most focused on, but there's really a threshold question when you're talking about ICOs, which is different from the Jobs Act. The Jobs Act regulation is on the books, and it's those who participate in that regulatory regime have an understanding of what their kind of obligations are and where they fall within that. In the ICO context, and what the 21A report makes clear is that there's an initial question you have to ask, which is whether something is or isn't a security, and the answer to that question has certain consequences. And I think right now, that's where the focus is in terms of both the industry and certainly us as the regulator, having that analysis on a case-by-case basis to understand whether someone is or isn't kind of in that bucket. I think what you're talking about is whether on top of that there's an effort to impose kind of a broader kind of regulatory structure, and I don't have any particular answer to you, can't speak to that directly. What I would say though is there is certainly specific parameters on the Jobs Act front, but the ICO market is, for a variety of regulatory reasons, is not that, and those are two kind of separate activities.
Young lady here.
So all day we've been discussing kind of what the world is doing regulation-wise, and one of the things that we touched upon is Singapore. Singapore has a regulatory fintech sandbox geared specifically towards giving fintech startups leeway in the eyes of the regulators. Without something like that, can the U.S. really hope to compete? I mean, is there something kind of similar in the works?
So, and there are a few other jurisdictions that also either have or purport to have some sort of regulatory sandbox. Look, I think we talk about can the U.S. compete, but the SEC and other regulators in the U.S. have certain authorities, whether exemptive authority, no action letters. They have certain tools where appropriate they can utilize to provide new firms and companies with regulatory relief where appropriate. So I appreciate the question, and I think it's an important one, but I don't necessarily buy the premise that in the absence of a formal regulatory sandbox, we can't compete. It doesn't mean that there's not value to it, so I'm not passing judgment, but I do think the SEC has tools in place and they've used them, for decades in various contexts, and I think that remains something at our disposal. On the other hand, I know there are other efforts. I think there is the legislation that has been kind of proposed in the past and others, so there in the U.S., so that there are ways to potentially modify that. But I do think, and this is why, and I'm glad you raised the question, why I'll again plug that our fintech at sec.gov email box, because to the extent there are concerns and considerations and entities operating in the fintech space in the U.S. or want to operate in the U.S., if you're concerned about those types of issues, certainly one step to consider in addition to getting Securities Counsel is to reach out to us.
If I may, I'll take another question, sir, right here.
Have people sought, and is the SEC willing to issue no action letters in an ICO area? And with your email box, do you issue guidance to that box for people who sue the
I missed the very last part of that. Yes.
If we submit a question to you, do you issue guidance to the body?
Yeah. So I can't speak to kind of what people have or haven't done in coming forward to us. What I can tell you in terms of answering your first part of your question, which is have people sought and or received kind of no action letters, what I can say is it's been a very diverse kind of group of firms and individuals who've come forward with a wide range of issues and a wide range of potential requests. And I leave that intentionally vague because I don't want to limit anyone in terms of thinking whether they should be coming forward. I think there's no kind of prerequisite in terms of what would be kind of an appropriate kind of question to receive, as long as it's about the securities laws and it doesn't have profanity. But in terms of the second part of your question, we're not necessarily in the business of providing kind of legal advice and guidance. That's what your securities counsel is for. However, by putting you in touch with the experts and the appropriate people within the SEC, to the extent it makes sense after those conversations that you may want to seek a request a no action letter or obtain some sort of exemptive relief, you are in touch with the people who would be responsible for or in charge of that process. So it makes for a much more efficient and productive communication and conversation. Well, everything's going to depend on the facts and circumstances. Like I said earlier, we generally focusing on conduct, not technology. So there are many reasons why we have and would consider issuing a no action letter that aren't necessarily unique to the DLT space.
All right, we're going to take one more question.
Have you issued a no-action letter, and are these a matter of public record?
With respect to initial coin offerings, not that I'm aware of.
Are they a matter of public record if they were?
Right. It all depends on the circumstances, but I'm not aware of, and I'll speak on something could have happened without me being aware of it, but I'm not aware of there being a no action letter that's been issued in the initial coin offering space.
All right, we thank George and Zach for letting us go a little long. They knew there was going to be great interest. A hand for Ryan.